Can councils take your kids off you if you're homeless? Now, clearly this is a really, really important question. It's one which is very much outside my comfort zone in terms of answering, because it's very much concerned the Children Act and the Human Rights Act. However, there is some stuff I can say. I have had cases where this has come up, and there are some things which I'm happy kind of saying, even though this is not going to be a definitive kind of video about the ins and outs of it all, but I think I can give some pretty firm conclusions about what the answer is. And essentially the answer is technically just about yes, but it's so difficult, it's such a high hurdle for councils to actually try and do that it basically makes it very unlikely. In fact, all the cases I looked through appeared to me to say that the children were not actually removed. Although the possibility was on the table, so to speak, it didn't actually happen because the families in those cases had alternative options. I might be misreading them, there might be some other stuff that happened after those cases happened, but that seemed to me to be what they were saying. And so although it's very difficult for councils to actually do it in practice, and I'll go through some of the kind of the safety features against it happening in a moment, the reason this is such an important question is that it seems that lots of housing officers threaten parents with this kind of this big threat, this big stick of taking their kids off them if they don't cooperate, and effectively coerce people into accepting lesser quality accommodation, lesser quality support than was enacted by Parliament. So one example of a situation I worked in myself was a lady I helped when she was fleeing domestic abuse, and she approached a different council. And the council actually gate-kept her and kind of failed in a number of other ways. But once the process was actually kind of followed eventually, the council moved her several times between different temporary accommodation units. And on the fourth occasion, I think for the fourth property that the council were looking to move her into, she was very, very reluctant to move there. There were some issues with the property itself. There were some other things she kind of pushed back on. She'd already moved 3 times before, and she'd had to kind of pay the removal cost each time because the council had not actually done anything effectively to protect her property. And so she had a conversation on the phone with a housing officer, and in effect what seems to have happened is a housing officer says, if you don't accept this accommodation, we could take your kids off you. I think actually it might have been stronger than that. The officer might have actually said, we will take your kids off you, but being generous to the officer as much as we can. That threat was certainly there. And the mum was obviously very distressed by this. She contacted me, she emailed me, she rang me up as well and basically said what had happened. And that particular complaint, the fact that the housing officer had threatened to do that, formed the basis of one part of the complaint as a whole. The complaint was upheld as a whole. As I say, there have been gatekeeping and other issues as well. And the family were housed in social housing about 6 months after all this happened. And I was very, very, I don't know what the word would be, pessimistic that the LGO would uphold this part of the complaint, because in effect it was the mum's word against the housing officers. And in my experience of the LGO, or the LGSCO I should say, is that generally they'll side with the council rather than the homeless person. Now, my experience of both homeless people and housing officers is usually the homeless person who's actually telling the truth. It's usually the housing officer who is being dishonest when this sort of stuff comes up. And you might think that's outrageous for me saying it. I could do many, many videos about all the things I've seen happen over the years, both working within local authorities and also challenging them. So that's kind of why I'm saying that. But generally speaking, people who are homeless, they're not trying it on. There will be those occasions when people do, but most people just genuinely need the help, and they're being straightforward as they can be. So the LGO final decision actually came back in her favour, which as I say, I was quite surprised by, but welcome kind of thing. And if I read from the final decision letter here, from the LGO, so I've spoken to Miss X, who provided a credible account of the advice given, as in that her kids might be removed, and I have no reason to doubt this. So this is in the face of, by the way, the housing officer and the council themselves denying all knowledge of it, saying, oh, this never happened. The LGO goes on to say, I note she reported her version of events to Mr. Y soon afterwards, that was me, which she included in the formal complaint he later made on her behalf, and that her account has remained consistent. I have no reason to doubt her account. So again, that's just kind of quite positive kind of outcome there. And the LGO went on to say, I also note that the council did not send her a letter explaining why it considered property 4 was suitable and explain the consequence of refusing, as it should have done. This means Miss X had no information on which to base her decision other than the advice she was being given orally, and so she could not make an informed decision. Now, the actual property ended up being infested with bed bugs, and all kinds of problems arose from it. At this stage in the process, we obviously didn't know about that yet. And actually that was something which fell outside the LGO's remit, so it was kind of more a housing ombudsman's remit rather than the local government social care ombudsman. But in putting this complaint to the LGO, I actually did a little bit of research because I wanted to make it as robust as possible. So I did a little bit of Googling and stuff, and actually found out that Shelter, as in the National Charity Shelter, had campaigned on this issue a few years ago, because the number of people who were obviously being advised that their kids might be removed from their care. So I kind of cited that and said, look, I made the point, balanced probabilities. This lady, this mum, has been shown to be credible with all the stuff she's saying. She's been shown to relay information accurately where needed. So all that sort of stuff was in her favour. There was some other BS that was coming from the housing officer as well during this period. So, for example, the property 4 that has been referred to, the housing officer told me it was actually temporary accommodation, and I googled it because I never trust housing officers generally. So I googled it, and yep, it came up. This is temporary accommodation. But was not actually temporary accommodation in the way that me and the housing officer would understand it. It was actually some kind of short-term accommodation which was not under Section 188 or Section 190 or Section 193 or anything. It was this kind of like ropey charity that was kind of offering it as a way of kind of ending the relief duty, basically. But yeah, so anyway, so this is the kind of situation that can come up. Obviously, it would be utterly terrifying to go to a council, ask for help with housing, and then get told, oh, we'll house your kids, but we're not going to house you. So yeah, I mean, it's just bad on so many different levels, so harmful on so many different levels. So looking at the case law, as I kind of did a bit of research, there was a number of cases which kind of discussed the issue in general. There was one which was particularly helpful, which is called Jalal v Greenwich, and I might be kind of getting a few of the details wrong, but kind of I think that the body of what I'm saying is true. The Jalal family had been found in intentionally homeless, or one of the parents had been found intentionally homeless anyway. And it seems that once the intentional homelessness decision had been given, Greenwich still actually offered some kind of accommodation for them, assuming it was suitable. I don't know for sure. And the family, the parents, actually turned that down as well. So it was then referred to Children's Services. A little bit about the law. Once a family's been found intentionally homeless, they should be asked for their consent to refer the case to Children's Services, who would then be able to provide additional support. And if the family don't give their consent, but the housing team have reason to believe that the children might be at risk, they make the referral anyway, to be honest. So that's just the way it works. Kind of safeguarding children is paramount. It kind of supersedes consent. So Children's Services would get that. They then need to carry out an assessment under Section 17 of the Children Act. And as I say, this is where my knowledge is not particularly kind of accurate here. But the assessment happens under Section 17. I don't know if the assessment happens for each individual child or if it's kind of like done as for all the siblings all together. I'm not sure. And effectively, the understanding is that any child who is without a roof is going to automatically be a child in need. And therefore, the local authority has a power to offer services to kind of meet those needs or kind of ameliorate those needs. So that's kind of what happened. So the children's social worker carried out an assessment, and in doing so and kind of looking at the facts in general, they realised that this family had a wider support network who probably on the surface at least seemed to be able to accommodate the family themselves. So bearing in mind the local authority had a power to do certain things, to offer certain services under the Children Act, it doesn't mean the same thing as having a duty. So they don't have to provide accommodation. They can do, but it's not kind of compulsory on its own. And actually what happened here was the parents refused to cooperate with those inquiries. They basically said, we're not going to give any details of our family. I don't know what the reason was given. They also made no real effort to actually find accommodation themselves. So they weren't able to evidence what they'd actually done to provide the accommodation. And in effect, what it seemed to be, and maybe this is unfair, I don't know, is that the parents had effectively said, we're going to just play chicken here. And if we hold out long enough, eventually Children's Services will house us. And that is not what happened, basically. Long story short, again, I don't know the full details of it. Effectively, the local authority were able to say, looking at your situation, in view of the fact you've not cooperated with inquiries, we can draw adverse inferences into that legitimately, which is upheld in court, that you actually have other options and you're simply not telling us what they are. And so should you not house yourself at this point, we will remove your child. We will house your children, but we won't house you. And as I say, I don't think it really kind of actually came to effect, because I'm assuming the parents did actually go and live with their family or their support network or whatever. But effectively, what the law is really trying to do here is to stop families like this family appear to be in terms of playing chicken. And there was even a bit in the case which kind of said, you know what, we don't want to have a situation where parents can spend their money on whatever and end up in a situation Children's Services ultimately will house them. So going back to this kind of overarching question just for a moment, can councils remove your children from your care? Technically, yes, but you literally have to ask for it. You literally have to break through several layers of the safety net there. So you have to be found intentionally homeless by housing team first, or refuse offers of accommodation from the housing team first and exhaust those options. Get referred to Children's Services, and in effect just don't cooperate with those inquiries. There were other cases I looked at where, for example, Children's Services identified that the family had accommodation in another country, and they said, we will help you get back to that country. If you refuse that offer of help, we will house your children, but we won't house you. But there's some other things that have to happen as well. So as I say, first of all, the needs of every child needs to be fully assessed, carefully assessed. The whole action of the local authority need to be, primarily be looking at promoting the well-being of the children. So again, there's this principle of we don't punish the kids because the parents have done something really stupid. Generally speaking, the council is going to make sure that the kids' needs are met, and in most cases that is obviously going to mean staying together with their parents. And once the assessment's been done under the Children Act, there is this additional assessment that has to happen under the Human Rights Act, which again, this is way outside of my kind of area of familiarity. But in effect, again, they would have to ask this question of, is it proportionate to separate these children from their parents? And these assessments will be subject to very strict and sceptical scrutiny. So there kind of be a very high level of evidence to show, or for the local authority to show, that it is proportionate and the right thing to remove children from their parents' care. And so again, I'm not trying to make this a definitive video, but here's some things which I think have to have happened for a local authority to be threatening to remove children from their parents' care. So there needs to have been an assessment under the Children Act to carefully assess the needs of the children, promoting their well-being, putting their interests kind of in the centre and front of what the local authority is doing. There needs to have been a human rights assessment taking place. In effect, the council has to be satisfied that there are literally no other options. And if a family don't cooperate with those inquiries, the adverse inference can be that, yes, they do have something up their sleeve, they're just not telling us, and a council can proceed on that basis. And so ultimately, unless you're literally just playing that game of chicken with the council and just thinking that you can hold out all the way, that is really the only, and just simply not engaging with other options, not even trying to find other options, not even trying to find alternative accommodation, that is the kind of situation where this sort of thing might be invoked. But even then, you're going to have lots of warning. They're not going to be able to do that lightly. They're going to need to go through a whole process, and that will give any sensible, sane parent plenty of opportunity to look at something else. So I think that's the kind of underlying principle is children's services will step in and house the whole family when there is no other option. But where there are other options, children's services will understandably be reluctant to do that, and it can ultimately come to a head in terms of this possibility that the children will be housed and the adults won't be. There might be a further thing to say about this, which I couldn't find any case law at all about, but I think in cases where the children are already known to children's services, as in they're already under a child in need or even a child protection plan, and the parents then essentially refuse to engage with support or refuse offers of accommodation or whatever that might be, then I think that's maybe more likely when it might become a factor of the children being removed from their care and accommodated under, I think it's Section 20 of the Children Act. Again, I'm not that familiar with it, but so I think it could be kind of the straw that breaks the camel's back, so to speak. Where there'll be in-depth and ongoing meetings involving support services, children's services, housing, all of those kind of professionals. The parents will be invited. And again, I think the parents are going to have to really be shown to just not be capable of managing their kids' needs and just kind of acting unreasonably, or kind of doing this thing where they think they can just hold out for something better and not do anything at all to actually try and meet the kids' needs. I think that's really the only situation that you're going to have in. But for a housing officer to threaten all this, to threaten to remove the kids, they're simply just not in the position to actually do that, because whilst the housing officer is still involved, they're still most probably under the Housing Act element of the support available to them. The assessment of children's services probably hasn't actually happened yet at all. And so until that's happened, until these assessments have been carried out under both the Children Act and the Human Rights Act, the council is just simply not in a position to threaten it, to say that's going to be the course of action. So I'm hoping that should reassure people. As I say, unless you're really trying hard to not cooperate with the council, they are not going to be looking to remove your children. That's I guess the kind of summary of it. But needless to say, as I'm sure most sensible parents do, you do need to be active in terms of finding other accommodation. If you've been found in tenancy homes, there are a number of other things you can do. So for example, if there's two parents in the household, if the dad's been found in tenancy homes, there's nothing stopping the mum making a fresh application. If you've turned down accommodation because you think it's unsuitable, that's not the best idea ever. It's going to be a stressful course of events that happens, but there's nothing stopping you reapproaching and making a fresh application. The decision might be that you're in tenancy home, so again, it's not ideal, but there are other kind of safety net features that are going to be in this process between you making a homes application and having your children removed from you. There's so many different steps. Some of them are going to involve judges and stuff like that down the line, so it's not going to be something that can be taken lightly, and certainly not something a housing officer just can kind of bandy about and just threaten willy-nilly. That is simply not okay. And as I say, if you come up against that sort of conduct from your housing officers, make a note of it immediately. You know, email a support service or something and say what's happened. Give a detailed account of what's happened, the time, the place, what was said, what wasn't said, all that sort of stuff, and then make a complaint to the local government social care ombudsman. And as we saw in the case I cited at the beginning, they can actually uphold it, even if you don't have, like, you know, an audio recording of it happening. As long as your account of it is credible and fits in with the wider facts of the case, then the LGSCO may uphold it. So yeah, hopefully that's, again, reassuring. If you're a professional and you hear that sort of stuff happening, I would hit the roof personally and just basically complain immediately, because that sort of stuff, it exposes how unhelpful some housing officers are and how quick they are to say outrageously distressing things just to get homeless applicants to kind of, you know, accept certain types of property which often aren't suitable. So yeah, don't tolerate this sort of stuff. If we tolerate it, it'll just continue. That's the way it works. But if you push up against it, I mean, I bet this particular council that is involved here, I would imagine certainly that housing officer themselves would have been very reluctant to try and say that sort of thing again in future, because I would imagine they probably got a bit of a telling off for it. I don't know, who knows. So yeah, any questions about it, as always, stick it in the chat and I'll take it to the next live stream on Thursday evening, 7:30 p.m. You can watch it anytime afterwards basically, and I'll index the questions to kind of, you know, so you can follow what's going on. Thanks to all those people subscribing. It's really just nice to see the channel growing and just kind of reaching more people. If you are seeing these kind of issues come up in whatever, you know, Facebook groups or whatever, feel free to share these videos in those kinds of comments, because it's still the case that there's so much misinformation about housing law around. It just makes it very difficult for people to know what advice is good and what's not. So again, you know, I'm just some guy on YouTube, so don't kind of take my word for it, but do check out the Jalal v Greenwich case. There's lots of kind of commentaries on it as well, and do kind of keep looking at the LGSCO decisions as they come out, because you're going to find situations like this one which they kind of just, you know, go through and kind of give what the actual law is as well. So that's a really good source of information. That's how I learned all this stuff basically. So yeah, hopefully that helps.